introduction for the sake of the record. My name is Martha Kome. I'm the chairperson of the Judicial Service Commission. I welcome you to this interview.
Thank you, my lady.
And my name is Machere Njero. I'm the vice chair, and welcome.
Thank you, my commissioner.
Good morning. I'm Oluwande Evelyn. You're welcome.
Thank you, Your Honor.
Good morning, Council. Jacqueline Ngutia, you're welcome.
Thank you, Commissioner.
Thank you, CJ, Chair. Good morning, Council. My name is Justice Mohammed Ibrahim, Supreme Court and the Commissioner. Thank you.
Thank you, my lord.
Good morning, Wakili. My name is Fatuma Sichale. Karibu sana.
Santi, my lady.
Good morning. My name is Charity Kisoto, Commissioner. Karibu sana.
Thank you, Commissioner.
Okay, good morning. My name is Isaac Ruto, member of the JSC.
Thank you, Mheshimiwa.
Good morning, Wakili. My name is Caroline Zilani. I'm a Commissioner. Welcome.
Thank you, Commissioner.
Good morning. My name is David Majanja, Judge and Commissioner.
Thank you, my lord.
Thank you, Honorable Commissioners, for that introduction. Madam Achieng.
Yes, my lady.
Before we delve deep into the interview,
Yes, my lady.
where the commissioners will be asking you questions relating to the application you have made for the position of the judge of the High Court.
Yes, my lady.
Kindly confirm to us your county and your ethnicity.
Thank you, my lady. And before I proceed, my lady, I wish to just notify your good selves that I have a minor flu. So I'll occasionally be blowing my nose, perhaps, and maybe coughing a little. Kindly indulge me. No, my lady, I'm on medication. I'm on medication. Yes. Thank you, my lady. I'm from Homa Bay County.
Your ethnicity?
I'm a Luo by tribe, my lady.
Thank you very much. Commissioner Macharia, the Vice Chair, will bring in the next set of questions.
Okay, just a few questions.
Yes, Commissioner.
Now, I'm looking at your CV, and
Yes,
I note that you've now practiced for more than 25 years, right?
Yes, Commissioner.
Which is quite a long time.
Yes.
Mainly in private practice.
Yes, Commissioner.
Now, could you tell this commission what is now propelling you to the desire to transition now to the judiciary?
Thank you for that, Commissioner. To be honest, first and foremost, I have had this desire for some time now. The first time I actually wanted to join the bench, I was very young. I was in my 20s, and I attempted to join the bench as a magistrate. That was in the, I believe it was in the year 2000 or thereabouts, Commissioner. And I wasn't successful at the time. That was in 2000 or thereabouts as a magistrate. I wanted to join as a magistrate. And then, so I continued with practice, and then the year 2018, I also wanted to join the bench actually in the year 2018. But I wasn't able to lodge my application because my plate was a little full. I had so many matters going on around my life at the time. So that was the second time. So I've had this desire for a long time. In the year 2022, I lodged an application, but I was not shortlisted, your Commissioner. So it's a desire I've had for a long time. And my main objective is to generally to give back to society. I've been in private practice for a long time now. I've been in practice for like 27 years now, and I have had exposure in basically prosecuting matters and defending matters. So I would really be honored to take it to another level and hopefully join the bench, so that I am able to help in making decisions. And this is primarily because I have a great passion for law. This is all I've done since admission to the bar. I have practiced law all my life, And by joining the bench, essentially, my primary goal is to give back to society, in the sense that I would wish to serve the society by being a judge and helping make decisions. And I'm hoping in my own small way, I'll be able to probably, of course, by making good decisions, being a good judge and everything, I'd be able to make the world a better place to live in my own small way. So
Okay.
yes.
I understand. Now, what do you consider to be your key achievements
Yes.
in practice
Yes.
that you think would be able to show your ability also to become a good judge? And you be very specific in the said achievements.
Thank you. Now, I would say to a very large extent, I have met my clients' expectations. I've met my clients' expectations in the sense that for the cases I've been prosecuting, for the cases I've been defending, to a large extent, and in all humility, this one I'm saying in all humility. In fact, when I was preparing for this interview, I was trying to even count the number of cases I've lost for the 20 years that I've been running my own practice. The initial 7 years I was working for various lawyers. But for the 20 years that I've run my own practice, to be honest, I believe I have met my clients' expectations. I have been, in my own small way, I've been a successful lawyer, in the sense that I've been able to handle my matters very professionally. So I've met expectations. That's one. I have been. I have a very strong work ethic. I am very hardworking. I believe so, with all humility, and I believe.
You know what? I'm trying to help you by requesting to be very specific, because you're competing with many people.
Yes,
so
yes.
if you're not able to deliver a punch,
okay,
by showing very specific achievements that resonate with the job of a judge,
very well.
so that they are not just generic statements.
Uh-huh.
With tremendous respect, I know you are hardworking. All those things you are saying.
Yes,
but remember, for the commissioner, they need to understand something that really speaks now to very specific achievements that will make you cut above the rest of the applicants.
Okay. So apart from the fact that I've met my clients' expectations, I have been able to. I have mentored students. I have, over the years, I've mentored quite a lot of students. I have been able to, Mr. Commissioner, I'm trying to think, because I wouldn't say that I have a case that has appeared in the papers or on TV, but I have, when I say I have met my clients' expectations, it's because first and foremost, I have been a straightforward lawyer. Okay, let me say I've been a straightforward lawyer, and being a straightforward lawyer, I have not cut deals, I have not followed shortcuts, I've followed the long path, and I have been able to uphold the rule of law in my handling of my matters. I've been guided by the rule of law. I've been guided by, I've been very, I've not had any prejudice. I've handled my clients on an equal basis.
Okay.
I don't have big fish, I don't have small fish.
Yeah, I appreciate.
Yes,
I never worry about the TV.
Yes, so I believe my achievement is the fact that I have met, as I've said, much as I've met my clients' expectations, the attribute that I believe I'll bring to the table is the fact that I have been, with all humility, I have been a straightforward lawyer.
Okay, fair enough. Yeah, the rest will be asked to. I was saying never worry about the TV. That's for the actors.
Thank you.
All right, thank you.
Yes, yes.
Thank you, my lady. Good morning once again.
Yes, good morning, Your Honor.
So let's imagine you are successful in your bid to become a judge.
Yes, Your Honor.
And your first day of work, you are posted at the Milimani Criminal Division, and you have murder cases coming for plea. So you've taken plea.
Yes.
And then the prosecutor makes very passionate submissions against bail, and you are required to make a decision. What are the factors you'll be considering in arriving at your decision?
First and foremost, after, of course, hearing the prosecutor, I'll assess whether the accused is is a flight risk, whether there's a possibility of him, yes, a flight risk. I'll also consider whether there is a possibility of him interfering with the intended witnesses. I'll also consider the gravity of murder is murder, I know, but I'll also consider the gravity of the offense and the impact it's had on the victim's family, in the sense that in the event that the accused is released, what impact would it have on the victim's family? I would also consider perhaps if it's a matter that has probably attracted national interest, perhaps, I would consider that.
What about the strength of the evidence of the prosecution?
Yes, I'll also take that into consideration. I'll also take that into consideration, while also trying to assess whether the prosecution still needs probably more time and such.
More time to do what?
More time to probably assemble more witnesses, perhaps. And
at the point of granting bail?
At the point of granting bail, I can only think of that for now.
Okay. Most times, yes, by the time, like the scenario I gave you.
Yes.
But can you think of any other scenario where you would be looking at the strength of the evidence? Because most time, by the time you're taking plea,
yes,
the strength of the evidence is still unknown to you.
Pardon?
By the time you're taking plea, are you able to assess the strength of evidence?
Not really.
No, not really.
So
is there any moment when you think in the course of a trial, yes, you should be able to apply that?
I should be able to,
apply the factor of the strength of the evidence of the prosecution in making a decision concerning bail?
Yes, I believe so.
At what stage?
At the stage where, because, essentially, bail is, it's one of the first steps that are usually taken before even a matter proceeds, even before the pre-trial, really the pre-trial, really. I would majorly consider. Come again, Yona. I don't know if I'm not getting your question. No,
I'm asking, in the course of a trial, we've already agreed that, yes, at the time of plea, the strength of the prosecution case or the evidence of the prosecution case is, yes, still unknown to you. We've agreed on that, isn't it?
Yes.
Yes. So at what point will that be a consideration when dealing with the issue of bail?
When dealing with the issue of bail?
Yes.
Let me just say at the pre-trial stage, Yona.
At the pre-trial stage?
I don't know, probably I cannot recall right now, my Yona.
Okay. Thank you, and I wish you well. Thank you, my lady.
Thank you.
To your statement that you want to become a judge so that you can help the society.
Yes, my lady.
There is this statement that there is an intersection of justice and poverty eradication. That is, justice has a key role to play in eradication of poverty. How would you, as a judge, ensure that you use the law to eradicate poverty?
To eradicate poverty?
Yes, or to simplify it, empower the society.
Empower the society as a judge? As a judge, my lady?
Yes. Using the law.
Yes, my lady. As a judge, I would ensure that I dispense with my matters as fast as I can.
Mm-hmm.
Expeditiously, my lady, so that we don't have especially like a situation where we have remandees who are unable to raise bail, and probably they've not been. The cases have not gone on and everything. So I'd try my best to dispense with the cases as fast as possible, so that at least there are not so many people who are being held up, because a majority of the you'll find a majority of in many cases, the offenders are people of lower income who are probably stricken with poverty. So I'll try my best to ensure that I deal with my matters as expeditiously as I can. That's one. Two, eradicating poverty. Two, I would, as a judge, I would, I'm trying to think. I would try to,
That's okay. I think you had not thought deeply about your statement that you want to become a judge so that you can empower the society. We can go to the next area, which is judicial review, as we know it,
Yes, my
under
lady.
the common law, is constrained in the way we look at matters. I want you to tell us the instances under the Constitution 2010 which have brought a shift in the way we now examine matters of judicial review, different from the common law.
different from,
Yes, the shift brought by the Constitution 2010 in the determination of judicial review matters.
okay. Now, there are matters that can result in judicial review that would fall under fair administrative action. And essentially, the Constitution of Kenya 2010, amongst in the Bill of Rights, there's a provision for fair administrative action. And it gives room for situations where if action is taken against a party, basically under the Fair Administration Act, there is room for the party to seek for judicial review before a court of law. Before a court of law. So there's
So
the
only
ambit of the
shift
Fair
you are
Administration.
saying is the Fair Administration
Yes,
Act.
yes.
So what are the principles that have come up under the Fair Administration Act that are different from the principles we applied under the common law?
So first and foremost, before a party is condemned, the party has to be made aware of the action that is, basically before action is taken, the party has to be given a chance also to, has to be given audience. Has
That
to be
is
given
under the common law,
under the common
where
law.
we looked at the process.
Yes.
But now under 2010 Constitution, there are new parameters.
My lady, I am aware of the provision that falls under the Bill of Rights, where fair administrative action is basically it's a right that is that is enshrined in the Bill of Rights under the fair administrative action.
Okay, I think there you will refresh yourself to look at the jurisprudence that has emerged that introduces other principles of proportionality and all
Very
that.
well.
Justice Majanja?
Yes, good morning. I'm looking
Morning.
at your sample writings,
Yes, my lord.
and you've given us varied sample writings from 2005, 2006, 2012, 2016, 2022.
Yes, my lord.
What influenced your choice of giving us these sample writings?
To be honest, first and foremost, your lordship, I was trying to first and foremost illustrate my writing skills. Like the opinion that I did in the year 2005, it was a year after I had set up my farm, and I was handling a matter that involved some big fish, so to speak.
Yeah.
Your lord.
Yeah,
but
I've looked at it.
yeah,
We've looked at it. So I was
Yes.
just wondering,
Yeah.
why didn't you give us more recent opinions, like 2022,
2020.
so that we see where you are right now?
Basically, my lord, what guided my choice of writings was the fact that I was trying to give a sample of the writings I've had over the years, And basically to show that I've been consistent.
Okay.
I've been consistent.
Okay, that's fine.
Yes.
Now, like this one of 2005,
Yes, my lord.
you have not referred to any authorities, eh?
No, I have not, my lord, if I can explain. This was an opinion that I was giving to laymen, with all due respect, and they were majorly foreigners. And I wanted to put it in a way that they would easily comprehend, to be honest, my lord.
Fine. Now, why is it that when you are doing judgments,
Yes,
you are
my
required
lord.
to cite authorities?
Authorities are supposed to add weight to, like when you're preparing submissions, ideally they're supposed to add weight to your case, in the sense that you see now when you make analysis, when you essentially an advocate is supposed to refer to these
So you are a judge now, why are
yes.
you referring to authorities?
Refer to authorities so that when I'm making a decision, I'm able to show that in this particular instance, this is the decision I'm going to make. And while making this decision, I'll refer to authorities that have had similar, probably similar issues, and I'll be showing that I have been also been guided by these authorities in making my decision, so that the parties are able to understand that, you know, there are two warring parties. So I need to show that I've been guided by these authorities, so that it's quite evident that I've been fair in my decision.
Finally, in
Yes,
one
my
of,
lord.
the decisions you have cited to us, you dealt with the issue of presumption of marriage.
Yes, my lord.
Can you tell us the latest Supreme Court decision on that subject? What it's about, what it said?
My lord, to be quite honest, I cannot recall. Let me just be honest.
Thank
I'm
you.
sorry.
Thank you, Justice Ibrahim.
Thank you, Honorable CJ.
Yes, my lord.
Council Agutu.
Yes, my lord.
I would not have gone to some of the questions my brother Majanja has asked you.
Yes, my lord.
But I think this was a bit extreme. In your sample number 2, so I have to ask you, in sample number 2,
Yes, my lord.
which he has the Honorable Judge has referred to,
Yes.
the issue of representation,
Yeah.
you have cited authorities.
Yes, my
But
lord.
authorities, one case was 1904, an English case. The second one is 1837, and you are handling a case of 2003. The second case is a judgment of the British from UK, 1837. The third case is 1904 again, UK, and then another English case, 1961. Another English case, 1976. Don't you think we had 2003? We had a precedent on presumption of marriage in Kenya up to the Court of Appeal.
Yeah, my lord, I appreciate your sentiments. I believe I probably ought to have been more diligent in that instance. I ought to have probably researched better, my lord, with all due respect.
Thank you.
Yes.
Thank you for that. What is, in your view,
yes, my lord.
the difference between institutional and decisional independence?
Institutional
independence and decisional independence of a judge, the judiciary.
Now, I believe institutional independence would touch on the judiciary as an arm of government, in the sense that the judiciary ought to exercise independence. There ought not to be interference from other arms of government. Decisional independence would relate to a particular judge when, like, making a decision, in the sense that when a judge is making a decision, a judge ought not to be influenced to have any external influence, be it political interference or influence from the high and mighty, the movers and the shakers, so that the decision that is made by a judge is fair, is basically unbiased and not influenced in any way. Yes.
Thank you very much. I wish you all the
lord.
best.
Thank you, my lord.
Thank you very much, Commissioner.
Thank you, Chair. Good morning once again, Council.
Thank you, Vakil.
At the global level, countries came together and came up with a UN SDGs, Sustainable Development Goals?
Pardon, my Your Honor. Commissioner, pardon, come again.
Okay, the question is, at the global level, countries came together and set up the United Nations Sustainable Development Goals, SDGs. I don't know if you've heard of SDGs.
SDGs, I have.
Okay, and at the African regional level, we have the Agenda 2063 with several aspirations. As a judge, how are you going to promote the SDGs and the Agenda 2063 at the African region level? If you could maybe highlight one or two SDGs, the goals, and the aspirations at the African Union level.
Commissioner, if you could just probably just read out the SDGs again in full. I don't know the name. Yeah.
Sustainable Development Goals.
Sustainable.
Yes, so there are 17 goals. I don't know whether you have had an opportunity to read and understand any of the goals. And then at the African regional level, we have the AU Agenda 2063 with 7 aspirations. Have you had an opportunity to interrogate those 2 documents?
Well, not quite, Commissioner, but I'll give it a try. I would probably say that...
maybe you could mention one goal and one aspiration.
Let me give it a try, Madam Commissioner. I would say from an African perspective, I would believe probably one of the goals would be to ensure that at least, and please pardon me, to ensure that there are probably at least every individual is able to access healthcare, good healthcare.
Okay, I'll leave that out.
Yes.
What is your understanding of structural interdicts?
Structural
interdicts.
Under what context, Madam Commissioner?
Okay, I'll leave it at
leave
that.
It at that then.
Thank you, Chair.
Thank you. Justice Ishale.
Thank you, Honorable Chair. Wakili, you've now been in private practice for a period of about 26 years.
Yes, actually 27 years, my lady.
27 years.
Yes.
In my own view, that is no mean feat for you to have remained afloat for all those many years.
Thank you.
But we would like to really understand what you do on a day-to-day basis. How many are you in the firm?
Now I currently have one associate, and I have 2 clerks, and I have 2 administrative secretaries.
And how does your working day look like on average?
On average, we assign, when we have matters coming up in court we usually assign I assign the associate various matters to deal with while I deal with the other matters. So my day usually starts with court work. The court session.
Is that on a daily basis, or like
no,
how many times in a week do you go to court?
I go to court like 2 or 3 times in a week, my lady, and most of the sessions are online. So what happens is that we have online sessions in the morning. So my day usually starts at 8. And
so you get to the office?
I get to the office at 8, and I basically just go through my emails. I go through the diary. I have a briefing with my secretary. Incidentally, I have like 2 offices. I have an office in Ongata Rongai and another one in Nairobi, a small one. So what usually happens is that when I'm at the Rongai branch, my associate is at the Nairobi office. So first what we do is that we report to the office at 8.
So when do you close the business of the day?
We close the business of the day at 5 essentially, but I usually extend. In many cases I extend. There are instances where we might extend probably to 6, but I personally I extend usually.
So
extend.
Having been in private practice for
Yes.
those so many years,
Yes,
and in your own view,
yes,
would you say that the work in your private firm
yes,
has increased, or is it decreasing, or is it static?
my lady, to be honest, I'm being honest here. To be honest, it's been, you know, in the beginning when I set up, it was relatively low. And then at some point, it really picked up. And then it also had low moments. And I basically, the same relates to, I think, the economy and the money in people's pockets, because mostly I deal with walk-in clients. I have a few corporate clients and everything. So I've had, it's been up and down, up and down. There are moments when it's been quite good. There's been a lot of flow, a lot of traffic. But there are moments when business has been low, to be honest, my lady. But I would say that there's growth in the sense that I've really grown from the young lady that I was when I set up to who I am now. I've really grown, my lady.
All right.
I've really grown.
So you, of course, you're a member of the Law Society of Kenya.
Yes, my lady.
Any other professional body where you're a member?
I am also, I'm a member of the Certified Public Secretaries, though I'm not really a practicing one, in the sense that I'm a qualified one, but I'm more
so
of a
majorly
non-practicing.
we can just talk about the Law Society.
Majorly Law Society.
All right.
I'm more of a just, I'm the everyday lawyer you meet in town.
Right, thank
Yes,
you.
thank
Thank you.
Thank you, Honorable Chair. I have only one question for
Yes.
you, Wakili.
Yes.
If you were to conduct a SWOT analysis today of our judicial system, would you pick 2 threats and 2 opportunities that exist, and how would you navigate about the threats?
A SWOT analysis, Madam Commissioner, if you could just, I know it's abbreviations.
The question
for,
is very clear, Wakili,
yeah,
please.
okay.
Yeah.
If I could just come again.
I said, if you could conduct a SWOT analysis of our judicial system today,
Yes.
would you pick 2 opportunities and 2 threats, and give us how will you navigate about the threats?
The threats to the judicial system.
First of all, list to us the opportunities and the threats. Then tell us, how do you go about navigating the threats?
I think the opportunities are immeasurable. I believe the opportunities are immeasurable, in the sense that there are opportunities for, with regard to the judicial system, there are opportunities for
the strategic plan for the judiciary.
I have, with all due respect, Madam Commissioner, I have looked at the blueprint that was unveiled by the Chief Justice, and I am under the presumption that it's a guiding blueprint for the year 2023 to the year 2033, and I believe it has expected outcomes that would bring about a lot of change in the judicial system. That's what I have in mind, Madam Commissioner.
So what are the opportunities?
The opportunities, the opportunities of growth, they're immense. In fact, the blueprint is a
I
very...
need 2 only.
2. There is a growth in the IT sector, in the sense that the judicial system is becoming more IT savvy. The e-filing system, the fact that the court is going to do away with a lot of paperwork. That's one. And then 2, there's the blueprint seems to promote the idea of parties seeking alternative justice services, alternative means of justice of dispute resolution.
Can you relax, Wakili? This is not an exam.
Yes.
There's some water there. Just relax.
Yes,
Give
Madam
me the
Commissioner.
threats.
The threats, the threats are interference. It probably, I believe the threats, in my own personal view, with all due respect. Sorry, I have a cold and it's making my mouth really dry up fast. I'm sorry. The threats, in my own personal view, would be probably...
You've talked of interference.
Interference from, I believe, not really interference per se, but the fact that the courts will issue sometimes orders and they're not adhered to by the executive. And it makes a mockery of the judicial system, in the sense that if the executive does not adhere to the court orders.
Any other threat?
The other threat would be, I don't know whether this would fall under a threat, this would be a threat, but the fact that much as we've had this online system of handling cases, cases are still taking too long, Madam Commissioner, in the sense that it makes it easier for lawyers to proceed virtually. But there have been so many adjournments. There are usually so many adjournments. So the threat is that the much as the e-filing system came about, sorry, not the e-filing, the virtual sessions came about, I'm not seeing like it's a, okay, on one hand, I'm seeing like it's also, it's not, in my view, cleared the backlog as fast as it should, because I see so many lawyers adjourning matters. The pre-trial conferences take so long. Matters are mentioned so many times.
Okay.
Yes.
Okay.
It's a great, because it really delays the delivery of disposition, the finalization of cases. Okay. It's a great threat.
All right.
Thank you.
View. Thank you.
Thank you, Chair.
Thank you.
Now, Madam.
Yes.
The Constitution places a lot of emphasis on leadership and integrity.
Yes.
What are the responsibilities of leadership under Article 73?
Article 73. Basically, a leader ought to be accountable. A leader ought to be accountable. A leader must be transparent. A leader must be seen to exhibit fairness and impartiality, be unbiased. A leader has to give, exercise, not be able to discriminate. A leader should give human dignity. A leader should be patriotic and adhere to the national values, as in like basically be fair, yeah, just basically exercise, also have integrity in probably exercise of administrative action, and yeah, and yes, a leader ought to be a person of good moral, standing.
Okay, I was a little bit specific to Articles 73, but it's okay, I think.
Maybe
no
my
problem,
gold,
but you
my
can also refresh. Yeah. All right, thank you.
Yes.
Thank you, Honorable CJ. Wakili,
yes,
please give me 4 reasons why a judge may recuse themselves from hearing a matter.
A judge may do that in instances where the judge probably knows the parties, probably has had any interaction. It could be from a personal level. Probably the judge is related to any of the parties. A judge can also excuse himself when there are instances where he also has an interest in the matter, or has had probably some interest, in the sense that probably it's a company that has come before him, and a company has sued probably another company, and he had some connection prior to probably appointment to a judgeship. A judge can also excuse himself or herself from a matter. There are instances when actually lawyers would probably ask the judge to excuse themselves from a matter. There are advocates who do this sometimes when they feel that probably the judge is showing bias, or appearing a bit not impartial. So the instances where lawyers will actually even push for a judge to recuse themselves. That's 3. And then I can only think of those ones for now,
Okay.
Madam Commissioner.
3 reasons why a judge may not recuse themselves.
When there is really no conflict of interest, even when parties insist that they excuse themselves, and there's really no justifiable reason why they should do that. The judge can actually refuse to recuse themselves. That's one. I'm trying to think. When there's no conflict of interest, I've said that. Okay, that's one. Two, I'm trying to think, Madam Commissioner.
Okay, maybe at one
I
time
think
you'll
my
need to
called-
go have a look
I
at
think
that.
my called, yes,
Okay.
yes.
All right, I think that's all from me. Thank you.
Thank you very much, commissioners, and thank you very much, Madam Achieng, for availing yourself. I think this brings us to the end of the interview. Pole sana for your code. Before we release you, if you have any question, you can also ask the commissioners.
No, my lady, I don't have any questions. I just wish to take this opportunity for allowing me to appear before yourselves. I am sorry for this, but I would wish to thank you for allowing me to appear before yourselves. It was an honor. Thank you.
Thank you. Take our greetings. You said you operate from Ongata Rongai and also
My
Nairobi.
lady.
We wish you well.
Thank you, my lady.
Keep up the good work you're doing as an advocate. We appreciate
Thank you,
the representation you make to clients to enable them access justice.
Thank you, my lady.
We will get in touch with you when we complete the exercise.
Thank you, my lady.
Have a good day.
Thank you, my lady.
And get well soon.
Thank you, my lady.